It is an established wisdom that the wheels of justice grind slowly, and this also applies to international criminal justice. Some of the first cases at the ICC, like Lubanga, have taken longer than cases before other UN tribunals. This makes international criminal procedure an easy target of critique. Long proceedings are not responsive to the needs of victims, nor to the rights of the accused. So what makes proceedings last several years? The obvious answer is cases are legally and factually complex. They involve a large amount of documentation, filings, and litigation. But this is not the only factor. Criminal procedure plays a role. The length of proceedings depends on the different steps in the justice process and their functions. And this is what we will explore in this video. How do proceedings evolve? The justice system typically involves several stages: the pretrial stage, the trial stage, and as the case may be, appeals and reparations. Each of these stages has different functions. The modalities vary across courts and tribunals. Let us start with pretrial. What does it imply? The pretrial stage comprises several steps. Proceedings typically start with the internal analysis by the prosecutor called the preliminary examination. The functions of preliminary examinations have given rise to considerable controversy. Preliminary examinations serve undoubtedly as a necessary gateway and filter for investigations. They help the prosecution to determine whether there's a reasonable basis to initiate an investigation. This involves an initial assessment of the information received, analysis of legal criteria such as jurisdiction or admissibility, and a final determination that there's sufficient ground to open an investigation. But preliminary examinations also serve certain other functions. In the ICC, they have been used as an instrument to highlight atrocities or to encourage domestic investigations and prosecutions through naming and shaming. This role is more contested since it is closer to human rights advocacy and more detached from the core criminal mandate to investigate and prosecute cases. One striking feature of preliminary examinations is a diverse time span and its unpredictability. The ICC prosecutor took only a few days to make that determination in the context of the Libya referral, while in the context of other situations, such as Colombia, Palestine, or Georgia, the office took several years. Some voices suggest that preliminary examinations should be subject to stricter timelines. The second step is the initiation of investigations. The investigation is typically led by the prosecution. Its purpose is to collect evidence and frame the case. The prosecutor may question suspects, victims, or witnesses, or take coercive measures such as searching premises or seizing evidence. The judge only plays a marginal role in the investigation. Judges may intervene to protect fundamental rights of defendants or the interest of witnesses or victims. The investigation typically leads to a decision to prosecute certain persons. The investigation should in principle end at the time of the confirmation of charges. Once investigators have identified a person, the prosecutor may request a warrant of arrest or a summons to appear before a pretrial judge. The application has to be based on evidence which satisfies the court that there are reasonable grounds to believe that the person committed the crime. The test is whether there's a certain probability that the person concerned committed the crime. The application can be based on a summary of available evidence. The prosecutor can request a sealed warrant to maintain a surprise element in relation to the arrest. One of the main challenges of international criminal justice is the execution of arrest warrants. International criminal tribunals typically do not have direct enforcement powers. Some persons may appear voluntarily before the court pursuant to a summons to appear, but the court cannot directly arrest persons since they do not have police powers. Often years may pass between the issuance of a warrant of arrest and the transfer of a defendant to the court. This is one of the main challenges facing the justice process. If persons are arrested, pretrial detention often becomes a problem. The defendant has a right to a speedy trial, but in several cases, defendants have been held for years in pretrial detention before they were actually tried. The prosecution used this time to continue its investigations. Human rights law places limits on the length of pretrial detention. Deprivation of liberty should be the exception rather than the rule. International criminal courts and tribunals are reluctant to grant interim release, given the seriousness of the charges. But in cases where defendants are held for an unreasonable period of time, they may have to release the person. The main focus of pretrial proceedings is disclosure and the confirmation of charges. What does this entail? The defendant must first of all be provided with a detailed description of the charges, including the alleged offense, the form of criminal liability, and the factual basis of the charge. Only what is properly charged may lead to conviction. Then, the evidence must be disclosed. The disclosure process is a fundamental feature of a fair trial and equality of arms. It ensures that the defendant is not ambushed at the trial stage. The prosecutor needs to disclose exculpatory and incriminating evidence to the defense. There's wide agreement that the bulk of evidence should be disclosed before trial. Defense disclosure is more restricted. The defendant has a right to remain silent. The charges are then tested in a hearing before the pretrial chamber. The main purpose is to determine whether the case should be sent to trial. The focus is thus on trying the work of the prosecutor rather than the accused as such. The former differs between international institutions. In the ad hoc tribunals, the confirmation of the indictment is relatively straightforward. It is based on a prima facie case and can be done in the absence of the defendant. According to this approach, the trial is the main forum of proceedings. At the ICC, the confirmation of the charges has a more elaborate function. It has three purposes: to protect the defense against unfounded charges, to specify the charges, and to streamline proceedings by ensuring trial readiness and preparing the trial. This is justified by several considerations. Time invested at pretrial is said to save time at trial. A thorough pretrial may be in the interest of the defendant, who needs to know the specific charges in order to mount an effective defense. It also allows judges to ensure efficient and effective management of proceedings. The standard of proof at the confirmation stage is more demanding than at the arrest warrant stage. There must be substantial grounds to believe that the person charged committed the alleged crimes. But in the first phase of the ICC, confirmation hearings took considerable time. Some say they have turned into mini-trials before the main event, the trial. For instance, in the Lubanga case, the decision on the confirmation of charges went to over 150 pages, although it only concerned one category of crime, namely conscription and use of child soldiers. Their criticisms that pretrial has actually duplicated the function of the trial instead of preparing it. Following pretrial, the case is transferred to the trial chamber. The defendant is officially an accused. The trial is the main stage where the prosecution and the defense present their cases. But the function of the trial goes beyond the interest of the defense and the prosecution. It is geared to establish the truth regarding the facts and circumstances charged. The trial typically involves opening statements, a presentation of the evidence, closing arguments, deliberations, and finally, the judgment. The core task is to decide on the guilt or innocence of the accused. It must be established beyond reasonable doubt. Afterwards, the sentence is determined. Throughout the legal process, legal decisions may be appealed. The Nuremberg and the Tokyo tribunals did not provide for a right to appeal, but today anyone convicted of a crime is entitled to a review of the conviction and the sentence. Appeals are typically not new trials, but corrective decisions. The appeal chamber reviews errors of law and errors of fact. In egregious cases, it may remand a case back to the trial chamber. Parties to proceedings are also allowed to appeal certain decisions before judgment. These are called interlocutory appeals. For instance, challenges to jurisdiction and admissibility should be solved as early as possible by the appeal chamber. Moreover, issues that affect the fairness and expeditiousness of the proceedings might require immediate resolution by the appeals chamber. So what can we take from this? In this video, we've learned that the justice process involves different stages. We've seen that many important decisions are taken before a trial starts. The pretrial phase may be of key importance to frame the focus of the trial. Second, we've seen that the criminal process needs to strike a balance between expediency and other interests such as fairness. The protection of the rights of the defendant is a central interest that runs through these proceedings from pretrial to trial and appeals. Third, we've learned that evidentiary standards evolve in the course of the proceedings. They become more demanding as the process advances. In the next module, we will explore more specifically how perpetrators are tried. I look forward to seeing you there.